This is Mid-Atlantic Women in Agriculture's Wednesday webinar, Food Safety and Liability. Our presenter today is Sarah Everhart with Agricultural Law Education Initiative. This session is pre-recorded, but Sarah has provided her email address at the end for all questions and comments. To view upcoming presentations, along with all archived presentations, please visit our website. And a special thank you to our sponsors. Thank you for listening.
I am going to be talking about foodborne illness liability and the Food Safety Modernization Act. I'm just going to be talking about the produce safety rule today. The Food Safety Modernization Act is a huge piece of legislation with 7 different regulations that implement it. It's sort of a beast, so I'm going to stick to the produce rule today, but if you have questions, other questions about FSMA or about anything that I talk about today, my email is going to be on the last slide. So if you have a question that you're unable to put into the chat box or a question that I'm unable to answer during today's presentation, hopefully you and I can email and I'll find you the answer after today. It's always fun to talk about foodborne illness over lunch. I will try to keep things not gross, but you know, kind of comes with the territory. So, like Victoria said, I work for the Ag Law Education Initiative, which is a bit of a mouthful. It basically means I am an attorney and I specialize in agricultural law, and I work for the Francis King Carey School of Law, which is the University of Maryland Law School in Baltimore. I actually work out of my home in Talbot County, and then I have colleagues who are also attorneys that work for the initiative that work for College Park, and then some folks down at UMES too. So we are a very collaborative program with attorneys all across the state and our mission is to help farmers. There's our website, and I will tell you a little bit more about that in a second. We're an Empower program. It's a program that brings together the different parts of the University of Maryland to try to create the best possible product, create better research, and be the best possible resource that we can be. Here's some of the resources that we have available if you're not familiar with our program. We have a website. There's our website. It has a lot of helpful information in it, and it sort of houses all of our research, our publications. We keep it updated with quarterly updates, helpful links for farmers. There's an event calendar on the right-hand side there that you can see. So it's a good thing to check if you're in need of some legal information or if you're wondering what events we have coming up. If you would prefer to call, if you think of something while you're driving down the road, you can call this number. This number actually rings directly to my cell phone, so I will be the one that picks it up. I can't help you sue your neighbor because I am no longer in private practice. I did do that for many years, but I can do legal research for you and answer your question to the best of my ability, and if I can't for some reason help you because we're crossing over into that line of providing legal advice, I can help find you an agricultural attorney in your area that can help. We also have a blog. There's the link to the blog. It's co-sponsored with the crop insurance program. We update it 3 to 4 times a week, and we try really hard to keep it entertaining, keep it relevant. We do cover national issues, but most of the stories have some sort of Maryland bent, and we write about things that we think would be interesting to Delmarva operators. Okay, a disclaimer. I'm an attorney, so I have to start with a disclaimer. But basically what I'm here to do today is just to provide you all with some legal education. It's not individual legal advice. Everyone's situations are a little bit different. So if you need individual legal advice on a foodborne illness issue or a FSMA issue, the best thing to do is to consult your private attorney. But hopefully the information I provide to you today will be of some help. All right, so let's start with an example. And I promised I wouldn't get too gross since this is a lunchtime webinar, but it's fun to start with an example just to kind of frame where we're going today. So we'll start off with an example of a farming operation run by 2 brothers. They grow fruit on their farm. They sell to large and small grocery stores and local farmers markets. They've been in business for a few years, and they started the business themselves. They had a third-party auditor come in and look at the farm, and they got a good food safety review. They got a passing review from the auditor, so that's all good. However, 3 weeks later, more than 125 people in 28 different states fell sick, and 33 people died after consuming their farm's fruit. So this is basically your typical nightmare situation in terms of foodborne illness. And hopefully the reason why some of you are listening today, because you want to know how to prevent this from happening. The illnesses and the deaths were traced back to the fruit's farm, and evidence showed that the fruit was contaminated at the farm's packing house. In this situation, the farm erred by using old equipment that wasn't actually suited to be washing cantaloupes, which was the fruit that caused the illness. It was equipment that was actually supposed to be used for potato harvesting. And they left out an important chlorination kill step. So just to finish up our example, the farmers actually ended up pleading guilty to misdemeanor counts of introducing adulterated food into the interstate commerce stream. They were facing a penalty of up to 6 years in prison and $1.5 million in fines. What ended up happening was the court ordered a 5-year probation and substantial fines. They allowed the farmers to keep working, hoping that they could earn some money to pay back some of the damages, but in the end, the farmers ended up filing for bankruptcy. How did this happen? Some folks get confused when we're talking about foodborne illness and criminal liability. I'm going to be talking about both criminal and civil today, but I like to get the worst scenario done right from the beginning. So let's start with criminal. Criminal liability in foodborne illness comes from the Federal Food, Drug, and Cosmetic Act. It's actually a fairly old federal law that is still good law today, and is actually the basis for the Food Safety Modernization Act, which we're going to talk about a little bit later. But under Section 402A4 of the FDAC, the Federal Food, Drug, and Cosmetic Act, a food product is deemed adulterated if the food is prepared, packed, or held under insanitary conditions where it may have become contaminated with filth, or it may have become injurious to health. So, in a lot of these cases, if you'll read about a farmer being held criminally liable, they'll talk about the food becoming adulterated, and that's why they use the word adulterated. It's because that's the finding that needs to be made in order to hold someone criminally liable for food which is injurious to health. Okay, so there's two different, obviously, since it's a criminal law, there's a felony violation and then a misdemeanor violation. To be found guilty of a felony, you have to have adulterated or misbranded a food, drug, drugs also fall under this law, but in our situation, today we're talking about foods. You have to have adulterated the food and then put the food in an adulterated or misbranded state into interstate commerce. And a person committing that act had to do that intentionally. So you had to do it with the intent to defraud or mislead in order to be guilty of a felony. And that is when you could be facing jail time and millions of dollars in fines and that sort of thing. So that is sort of your typical egregious, very egregious situation. And our example here is bribing a USDA inspector or an FDA inspector. So you'd have to do something fairly egregious to be found guilty of a felony under that law. However, a misdemeanor conviction is a different story, and a misdemeanor conviction does not require proof of fraudulent intent or even of knowing or willful conduct. So a person may be convicted of a misdemeanor if they held a position of responsibility or authority in a firm, which is the FDA's word for operation, such that the person could have prevented the violation. So in a lot of cases, in terms of when you see farmers being held liable, criminally liable for foodborne illness, you'll see that they're misdemeanor charges because that basically just means they were the owner or the manager. They could have prevented the violation by doing things like having stricter food safety procedures. And convictions under the misdemeanor provisions are punishable by not more than a year and fined not more than $250,000 for both or each. I talk about criminal liability today just because I want people to be able to understand it. I don't want to scare anyone, but the FDA is pursuing more criminal charges. I know there's been, most people have heard about the peanut butter case. There was recently a case about some peanut butter that there was some very intentional acts that people were purposely putting out peanut butter into interstate commerce that they knew was harmful. And it just seems to be rising in popularity that the FDA is pursuing these criminal charges. So I hope that we don't see this in the farmer context, but it could be possible, and I just want people to understand the law that gives the FDA the authority to do this and the different legal standards there. So you might have recognized the example that I used. It is a true story. It was a farm called Jensen Farms out in Colorado, and it was a cantaloupe listeria outbreak. Listeria was the culprit in that one. So obviously nobody wants to be in that situation. How do you avoid that fate? The best way to avoid the fate that the Jensen Farm folks found themselves in is to plan, to follow GAP practices, comply with FSMA, like we're going to be talking about a little bit later, and be obviously proactive about prevention. The best defense is a better offense is the best way that I can put it. All right, so let's talk about civil liability, because civil liability is also very prevalent in foodborne illness cases and comes into play when one of these situations arises. Most foodborne illness cases are brought under one of these theories of civil liability that I'm going to be talking about now. These do vary state by state. So the material that I'm going to be presenting today, this is all accurate in terms of Maryland, but different states have different laws pertaining to civil liability. But in terms of Maryland, we have strict product liability. And strict product liability is most likely the claim that someone would bring and prevail in a foodborne illness case in Maryland, and in any case, and in any state that had strict product liability. The standard is that a party who manufactures, sells, or distributes a defective or unsafe product is subject to liability for harm to an injured person caused by the defect. So you might be thinking, this doesn't really sound like food, Sarah. This sounds like I bought a vacuum cleaner and the vacuum cleaner caught on fire and I'm going to sue Dyson. Well, it's exactly the same legal theory. You can bring a strict product liability claim for food. You can bring it for a vacuum cleaner that catches on fire. The party that manufactures the product, in this case, is the farmer, and the product is food. So if you manufacture unsafe food, you can be subject to liability for harm to an injured person caused by that unsafe food. The elements of the claim are that the product was in a defective condition, or in the case of food, unsafe, was unreasonably dangerous, contained a defect which caused the injury, and was expected to reach and did reach the end user without substantial change in its condition. So it has to be an unsafe food in an unreasonably dangerous state, contained that unsafe issue that caused the injury, so your food has to be proven to be the cause of the injury, and it was expected and did reach the end user without a substantial change. Strict product liability is a popular claim because the party is responsible without proof or fault for injuries caused by the products he or she manufactured, distributed, or sold. What does that mean? That basically means that if the injury is proven to be caused by the food, and the food meets those elements that I just outlined, the food was unsafe and the unsafe food caused the injury, the party who manufactured the food is found to be responsible without proof of fault. So that means you didn't have to do it intentionally. If that causal link is made, you can be held liable. Some other theories of liability, a lot of times if one of these suits are brought, a lawyer is going to throw in more than one claim. There's a claim called breach of implied warranty of merchantability, and that's similar to strict product liability. No showing of fault is required. Liability is established if the evidence shows that the product was not reasonably fit for the ordinary purposes for which it was sold, and that defect proximately caused injury to the ultimate consumer. This, again, is a claim that could be brought for any type of a product. It's just It's a general claim that we have in Maryland that says, look, if you're going to sell something and you put that product out into commerce, it should be fit for the purpose that you're selling it for. And if you sell something and it's not fit for the ordinary purpose, and it injures someone, you can be held liable for that. And finally, negligence, which is a claim that we've probably all heard of, and that's just a breach of duty of care that causes an injury. Negligence is a more difficult claim to prove, so lawyers might throw it into a suit, but in states that have strict product liability, like our state in Maryland, a lot of times negligence isn't going to be the claim that wins the case because it's more difficult to prove. You have to prove a breach of that duty of care, and in this situation you'd have to prove that a farmer had a duty of care, such as a duty to maintain certain food safety standards, and that they failed to maintain those food safety standards, and it's more complex. And strict product liability is easier to prove if you're able to prove that causal link. So, causation in a foodborne illness case, this is what I've been talking about. That causal link in a case of E. coli or Salmonella, that can be very difficult to prove. If you're talking about an individual case, you know, 1 or 2 people getting sick, unless it's part of a wider outbreak. That Jensen Farms example, obviously, that was a huge amount of people who fell ill. You know, what I would consider a lot of people that died because of that food. So that was part of a wider outbreak. It was easier in that situation to trace the cause of that injury. A lot of times, you know, maybe if 1 or 2 people fall ill, it's not as easy to prove that one product from one farm caused that injury, and if the lawyers aren't able to make that causal connection, then the claim will ultimately fail. One thing to just keep in mind, that if proven, if that causal link is proven, everyone in the chain of distribution, and this would be in the case of, you know, not a direct sale, but if a food product was, you know, put out, you know, sold to a wholesaler and then sold at a grocery store or sold in a restaurant, everyone in the chain of distribution could be on the hook for all the damages. The injured party has the choice to sue the deep pocket, and that's what you may have heard about joint and several liability. We have joint and several liability in Maryland, and that's what it means, is that everyone in the chain of distribution could potentially be sued and found liable, and the injured party then has the right to sue the deepest pocket. So in that situation, they might sue Giant if the tomato was sold at Giant. But then if Giant says, hey, we didn't have anything to do with you know, the Salmonella on that tomato, that came from the farm that way, that wasn't us, then Giant will turn around and sue the farmer. So basically, the legal system is set up so that the injured party can sue the deepest pocket, and then if the deepest pocket who is sued is not actually at fault, that person will then turn around and sue the farmer and bring the farmer into the case. So it's just one sort of nuance to understand about foodborne illness cases in Maryland, or any state with joint and several liability. All right, so now I've scared you all. I apologize, talking about criminal liability and civil suits, and hopefully everybody's still listening. So let's talk about some defenses, some good news. How do we get out of these cases, or what can you do to, what can you assert to try to knock down these claims? One thing you can assert is assumption of the risk, and that comes into play if the user or consumer discovers the defect, is aware of the danger, and nevertheless proceeds to unreasonably make use of the product, and is thereby injured, then he's barred from recovery. So if it's clearly an unsafe product and the consumer ignores the danger and consumes it and then becomes sick, if a farmer is able to prove that, then the injured party is barred from recovery. So it's important to keep this in mind if a consumer calls with a complaint about a product. I know at the Ag Law Initiative right now we're working on a publication. I see a question, would that apply to raw milk? I think that's a good question. It would apply to any product, I think it would depend on the application of all of these defenses, and some of these, I call them defenses because that's a word that we're all used to hearing, and a lot of these are simply factual assertions that a farmer would need to make to discredit someone's claim. But yeah, it would apply to raw milk if you were to tell in a situation, if you were to clearly label a product as expiring after a certain date. I think assumption of the risk, if somebody consumed an expired product, they're clearly aware of the danger of consuming an expired product, and if they drank it anyway, I don't think that they would have a very successful claim that it was an unsafe product, because we all know that those expiration dates are there for a reason. They're there to tell us when products are safe and when products are not safe. So anyway, what I was saying is that at the Ag Law Initiative, we're working on a recall publication right now, and one of the parts of the recall publication to try to help farmers come up with recall plans, and part of it is a questionnaire that farmers can use when a consumer calls with a complaint. So if a consumer calls with a complaint about your food, it's important to get a lot of information from them, and one of the pieces of information that you should get is when they purchased the product, how they've stored it, and how they consumed it. You want to get as much information as possible so you can assert some of these defenses, and I'll bring that up again in a second. Another defense is contributory negligence. This would apply if somebody's suing you under negligence. This isn't a defense to strict product liability, but in Maryland we have pure contributory negligence, which is fairly rare. A lot of other neighboring states such as Delaware have comparative negligence. But contributory negligence means that if the injured party's negligence contributes in any degree to the injury, the contributory negligence is a complete bar to the recovery. So that says defendants there. That should actually say plaintiffs. So if the plaintiff's negligence contributes in any degree to the injury, then it's a complete bar. So if you can prove that they were negligent in handling the product, such as undercooking meat or leaving a product such as raw milk that should have been refrigerated, leaving it out in their car for hours before they consumed it, then that contributory negligence should bar the claim. Product misuse is another one that falls under that same category. There was a recent case in New Jersey that fell under this. That comes into play when the seller is not liable where injury results from abnormal handling or use of the product. So this would be something that a farmer would try to prove that they shouldn't be liable because the injury actually resulted from abnormal handling or mishandling. The New Jersey case that I talked about, a person sued a farmer because they got sick from some pork. The farmer was able to discredit the claim by proving that the person hadn't cooked it thoroughly enough. So in a deposition, they were able to get out question the plaintiff and prove that the cooking hadn't been done to the regular standards. Finally, directions and warnings. If warnings or instructions supplied with the product are disregarded by the consumer, and where if used in accordance with these warnings, the product would be safe. So this would be the situation with refrigeration. So if you were selling a product that should be refrigerated, you should definitely label it with a direction or warning. Same thing with washing. If you're selling a product that should be washed before consumption, I'd recommend that you clearly label it must be washed before consumption, because if the warnings or instructions are supplied and then they're disregarded by the consumer, and if they had been followed, things would have been safe, then that's something that you could assert later down the road. Another defense, we have this in Maryland, it's called the sealed container defense in Maryland. Other states have it and they call it a passive seller defense or exemption. This protects the seller from liability when the seller receives possession of a product that they could not have become aware of a defect or alteration or caused the defect or alteration. So this comes into play when, let's say, you have an on-farm market and somebody from down the road says, hey, will you sell my jelly at your on-farm market? And you say, yeah, sure, I'll sell your jelly. They bring it over, it's in a jar. You had no idea or had no way of possibly knowing that the jelly in that jar could have been contaminated. You didn't store it in any way that added to the contamination or caused the contamination. you're able to assert this defense, and that should save you from being found liable within that chain of distribution. Things that get in the way of making this a good defense are, if you were selling someone's milk and your freezer went on the fritz, obviously you wouldn't be able to assert this, because then your lack of keeping that at the proper temperature could have possibly contributed to the defect. So this really, it's a narrow defense, but it's an important one, and one that can protect farmers if they're selling other people's products and they're sealed products, and they would have no way of becoming involved in that defect. Okay, I'm going to move on to the Food Safety Modernization Act. Foodborne illnesses are a complex topic, so if anybody has any other questions about that, feel free to email me and I'll go into greater detail with you via email. The Food Safety Modernization Act, we've all been hearing a lot about it recently, and that's a little bit odd because it was actually enacted back in 2011. So it's been in a law that's been around for a while. The U.S. FDA is responsible for the implementation, and the reason we're just hearing about it now is because the major FSMA rules are now final. FSMA calls them rules. We're used to calling them regulations. That's really what they are. They have the force and effect of law. They're more specific. So the FDA comes up with them, puts them in the Federal Register, and they provide the detail for how FDA is going to expect people to comply with the more broad mandates of FSMA. So there's 7 of them. You'll hear them referred to as the 7 final rules. The one I'm going to be talking about today is the produce rule. I chose that one because I think it's the one that's probably going to have the most effect on farmers. However, there are other ones, such as the sanitary transportation rule that could come into play if you transport your food. And there's the preventative controls rule, and that comes into play if you're doing any kind of processing of food. So let's talk about the produce rule today. But those 7 rules, they're going to affect you differently depending on where you are in the food system, if you're a retailer, supplier, manufacturer, and like I said, if you do any kind of processing, or if your products are sold domestically or internationally, because there's some international requirements as well. So the final produce safety rule was published November 27th, 2015. It was published on that date. It became effective 60 days later. They publish it, and then it doesn't actually become effective until 60 days later. So when we're talking about the effective date, actually add 60 days onto that November 27th date. The rule applies to farms that grow, harvest, pack, and hold food for human consumption. I'm going to talk about the rule a little bit, and then at the very end I'm going to talk about applicability. So if you're wondering about whether or not this rule applies to you, hang on, and I'm going to get to that part. But let's talk about what the rule requires first. There's some key requirements. One of them is worker training. So the produce rule requires training for supervisors and farm personnel who handle produce covered by the produce rule. Unfortunately, this little teensy-weensy overview that I'm giving today does not count as training. I am going to tell you at the end some news about the produce rule training that I just learned yesterday. So there will be some produce rule trainings that will be coming up, and that's a good thing to keep your eye on, because it's a legal requirement that people get the proper training under this law. Health and hygiene. The rule requires farm employees to follow sanitary practices, including but not limited to hand washing, not having your employees work when they're sick, and obviously maintaining personal cleanliness. The health and hygiene rules are very similar to GAP standards if you've gone through GAP certification. Agricultural water. There's a lot about agricultural water standards in FSMA. Water used on produce must be treated to make the water safe and of adequate sanitary quality for its intended uses. Microbially safe for washing hands, food contact surfaces, directly contacting produce during and after harvest, and then sprout irrigation. Sprouts are treated very differently than other types of produce under this rule. If you do grow sprouts, you really have to learn about FSMA. And so email me if you grow sprouts, because sprouts are a little bit of a headache under this rule. So back to water, irrigation water, and I'm not a scientist, I'm a lawyer, so I put these standards out there, but I can help you get in touch with people at the University of Maryland who are food safety scientists who can help you understand this if you need to break this down in more detail. But generally it's the recreational standard for generic E. coli, and corrective actions are required for water not meeting the microbial criteria. There's a lot of testing of untreated water, so obviously if you're not using water that's already been pre-treated by some sort of municipal system, testing is required. I provided a link there so that you could look further into that if you're curious about the water testing standards. We are also going to be touching on this at our Agriculture and Environmental Law Conference, which is on November 18th. So if you want to know more about agricultural water and FSMA, that would also be a great event for you to attend. But if you use untreated water on your produce, I recommend that you take a look at that link and start figuring out when you're going to start your water testing, because although we're going to get to compliance deadlines here in a few slides, you might need to start testing your water a year or two before your actual compliance deadline. So it's a good thing to get out in front of and think about early. Some more requirements: biological soil amendments of animal origin. So the rule requires specific types of treatments, methods of application, time intervals between applications of certain soil additions. The FDA is still working on this. Currently, the application of at least 120 days prior to harvest for crops that touch the soil and 90 days prior to harvest for those not in contact with the soil is the standard, but that could change. Domestic and wild animals are covered under the produce safety rule, require certain standards for domesticated animals, such as waiting periods between grazing and crop harvest. Wild animals requires farmers to monitor for wildlife intrusion and not harvest produce that is visibly contaminated. And there's rules about equipment, tools, and buildings, sanitary standards for tools and equipment that come into contact with produce, and buildings and facilities where raw fruits and vegetables will be held or packaged. And there's our old friend, the sprouts. Like I said, the rule has very specific separate standards for sprouts. Okay, so does this rule apply to me? I'm sure you're probably thinking, Lord, please let this rule not apply to me. Well, I'm going to try to help you explain or answer that question here in another slide by telling you who the rule doesn't apply to. However, the National Sustainable Agriculture Coalition created a flow chart to answer the question, and in that flow chart, they also answer the question if the preventative rule, which is for people that do any kind of processing, if that rule also applies to you. So if my explanation doesn't make any sense, or if you're more a visual person and you'd like to see a flow chart, I included that link so that you can go ahead and take a look at that. I like the flow chart. We actually put it up on our blog a week or two ago because I think it's well done and easy to use. All right, exemptions. So these people are not covered by the produce rule. If you're producing produce that is not a raw agricultural commodity, produce that is rarely eaten raw. And I know a lot of people sometimes have questions about that because some people eat things raw that don't eat and other people would never eat that raw. So that is a link to the foods that FDA thinks are produce rarely eaten raw, such as potatoes and things like that. Food grown on the farm for personal consumption. Food grains such as barley, oats, rye, things like that, they're not covered. And farms that have an average annual value of produce sold during the previous 3 years of $25,000 or less. So if you fit any of those categories, it doesn't apply to you and you don't need to worry about it. Then we have some other people that have either a modified or qualified exemption from FSMA. There's a modified exemption for produce that will be processed with a kill step. So if you're growing tomatoes and they're going directly to be canned, that's my example there of someone that would probably fall under the modified exemption. Because the produce rule is really to cover produce that is grown for raw consumption and is just going to go right, into that commerce stream and eaten raw. So if you're growing food that's going to be processed with a kill step, you're going to be subject to some record keeping and compliance requirements, but you're not going to be subject to all those other produce safety rule measures that I just went through. So if you think you might be eligible for a modified exemption, I would look on the FDA website and read about that and make sure that you do qualify for that. And then there's the qualified exemption, which is slightly different, and that is for farms that have food sales. This is the only rule that uses food sales as opposed to produce sales, so that's why I put that in bold and underlined it to make sure you understand that that's a difference between produce and food. This one used total food sales averaging less than $500,000 per year during the previous 3 years. You do a 3-year average, and the sales are directly to the consumer of the food. Restaurants or retailers in the same state or not more than 75 miles away must exceed sales to all others combined in the 3-year average. So you can do some sales to wholesalers, things not directly to the consumer, but for the most part you're selling your food to what the FDA calls a qualified end user, which is either directly to the consumer, a restaurant, or a retailer. Subject to, if you fall into that one, you're going to have to do some record keeping and you have to do some labeling, but you won't have to follow every single provision of the produce rule. Okay, compliance dates. So they've broken down the compliance dates based on the size of your operation. So if you have what they consider a very small business, that means that you made more than $25,000 but not more than $250,000 in average annual produce sales during the previous 3-year period, then you'll have 4 years from the effective date of the final rule to comply. The next one is small businesses, so that's businesses that make more than $250,000 but not more than $500,000 in average annual produce sales during the previous 3-year period. Those folks have 3 years from the effective date of the final rule to comply, and then everybody else has 2 years from the effective date of the final rule to comply. However, there are certain aspects, such as the water quality standards and related testing and some record-keeping provisions that have an additional 2 years beyond each of the compliance dates for the rest of the final rule. So depending on where you fit into that last slide, for example, if you fit into the small business category, you have 3 years from the effective date of the final rule to comply with the produce rule, except for some of the water, you would have an additional 2 years beyond that 3 years for some of the water quality standards and related testing. However, like I said before, for the water testing, you're going to need a couple years of testing results, so don't wait to start testing your water. I would view this water testing requirement as I would put it on your to-do list of things to do, starting this year, to start testing your water, to be prepared to comply with FSMA, so that you have plenty of testing years to rely upon, and that so you aren't pressed up against that deadline. All right, so the good news is that the produce rule requirements are consistent with the Maryland Department of Agriculture's GAP and USDA GAP programs. So if you're GAP certified, if you're following GAP procedures, you're most likely already complying with FSMA, which is good news. The one deviation from that is under the water quality, the number of tests required are more intensive than those required for GAP. So again, like I said, those water testing requirements are the things that's where the produce rule requires more than most folks are probably used to. The produce rule requires specific training, like I said, and the training has to be approved by the FDA through the Produce Safety Alliance. I've been in touch with the Maryland Department of Agriculture about this. They have had, both the University of Maryland and the Maryland Department of Agriculture have had some folks who have taken the training course and they were waiting, and they just heard yesterday that they're approved to actually hold training sessions, so that is a good thing. And they're going to be having some this winter and early spring. So stay tuned for that. Our website would be a good place to look for those dates, or MDA would also be a good place to look for those. So those trainings will start this winter and early spring, so that's good news because we didn't know that until recently. So the produce safety trainings will be specific on all those categories that I went through, and hopefully provide folks with the training they need and the specificity they're looking for, and then attending those trainings will be complying with the training requirement of the law. So just to wrap up, yes, Rosemary, I think that Victoria normally puts the webinars up, so you will be able to see this later. And if you want me to email it to you, you can just email me and I will email it to you so you can have it too. To wrap up, many producers fear that compliance with FSMA or any new law will cause more problems, strain resources, create disruption. But compliance does not need to be a massive headache. And many producers have been implementing the best practice guidelines that are going to be required by FSMA for years anyway. Like I said, if you're GAP certified, you're already going to be 90% of the way there. FSMA is going to be just offering you an easy to follow checklist is the most positive way that I can say it, but it's it's going to be requiring folks to follow those food safety procedures, which will hopefully make for a safe and better product. And there is my email. I hope I provided some good information today. Like I said, please be in touch with me if I can do anything else. And my colleague, Ashley Ellickson, also created this program with me.
Thank you for watching our archived presentation of our Wednesday webinar. If you would like to see more archived Wednesday webinars, please visit our YouTube channel. Or to find a schedule of upcoming live webinars, visit our website.